regularization, which we have posted on 7th of July. Yes. But give one number so that we can tag that.
This is the same matter or different matter?
Different.
Different matter.
It's a different matter. Any urgency pleaded?
That is content proceedings pending.
Proceedings when they are posted.
That is next.
Call.
They have filed content.
They have filed.
Yes.
You move a memo when okay, then it will be difficult for you. Call day after. We can have Yes. Yeah.
I beg your pardon, Your Lordship. This was a phrase matter filed by the peon attached to the court manager, Your Lordship, for regularization. This is a phrase matter.
We got next.
Pardon to mention, my lord, one interport appeal matter.
Yes.
That is this is 24. That matter was heard at length, but judgment was released by the judgment or not pronounced. So
Not pronounced.
No.
Judicial officers matter.
Matter was released, my lord. Matters are
Not of this bench, sir. When you are mentioning that, you are attributing it to us or somebody other bench.
no, that matter was heard
By other bench.
by Chief Justice, Honorable Chief Justice.
Now it is released.
Released,
So it comes before roster bench before us.
my lord.
Which year?
24.
After 3 weeks. Yes. Post after 3 weeks.
Pardon to mention, my lord.
Need not ask for pardon. It's your right to ask for. We may say yes or no. Yes. We need not say pardoning for everything. Why we should? Where is the question of seeking pardon?
Sorry.
Yes.
One content matter, violation of the division, honorable division bench.
Sir, give your memo. When do you want?
When do you want?
Next week, madam.
Next week. You can distribute it so that it shall
Not
not be
necessarily next week. It could be distributed according to the
some
case.
according to that.
So fresh admission matter, Lordship. By virtue of the.
When do you want?
Lordship.
Suppose it after 2 weeks.
Fourth, Lordship.
Yes.
Fourth, Lordship, because by virtue of the judgment passed by the Honorable Single Judge, the present respondent is filing the content petition. The content petition is directed to be listed on 7th.
7th. Call this matter on
Matrimonial appeal. It is fixed for 20th June, but not listed on the date.
He's mentioning that some have gone out of list. Redistributed at times.
We have redistributed. It will come. Okay.
But give the memo.
Give the memo so that the RPX will be reminded.
But please mention that it was directed to be listed on the
My lord, item number 7, my lord. It was in bold.
You should have we will do one thing. When still a lawyer is mentioning, do not interject. That will disturb you. Yeah.
What rate of 2000 conflicts in man? We have listed.
After 3 weeks. Yes. Yes, brother.
Item number 7, my lord.
then page wise, sir.
Page 1. Yes. Next.
Page 1, my lord. I beg pardon to make a mention. Page 1, item number 3, my lord.
Item number 3.
My lord, I am appearing for the respondent. Now I don't have any instruction to appear because I.
Let us see when your matter reaches. We need not call page 1 at all. 1 to 10 will not be called. That's the procedure in most of the high courts. Perhaps here also. Unless very here also. Yes. Page 2.
Page 2. Item 3 then.
My lord, item 7, my lord.
7 you can't mention. You have to wait till 10. Yes. No question of mention. They are against adjournments. Yes.
Page 3. Page 11 to 70.
Next.
Page 4. 18 to 25.
Next.
Item number 21.
21.
I am here for a senior due to some personal difficulty is unable to appear today. Therefore, I take the adjournment.
Okay. Hello.
My lord, item 20.
Okay. You oppose that? You don't oppose. Please wait. After 2 weeks. Yes.
But please inform your learned.
Your friend you have to inform. Okay.
You are for the appellant. 21.
Appellant. And if you do not inform, if he is waiting here, he or she, and if he mentions, we will take up the matter. Because we can't make the advocates to pick the board. They have to spend time in the library. They can't wastefully sit in the court hall idle. Is it not? Therefore, you have to inform your other side, saying that we have taken time. Yes. After 2 weeks, at the request of.
Then five.
Mention 20.
My lord,
item 0. Just give us serious mention.
20.
We are seeking instruction from the client, kindly grant 2 weeks time.
All 2
It's
weeks
for the other sides. You are for the respondent.
No, from that.
It's after notice matter. You have to inform the respondent. The same thing.
Same thing applies to you also, which we told your sister, our sister also. That applies to you.
We already got the other side.
That's wrong. Suppose if we don't grant adjournment and he will keep away from the court because you have informed, that will be dangerous. Yes.
My lord,
3 weeks after.
You have taken consent.
my lord, item 26. I am
They are speaking. They are speaking. We should respect your colleagues also. Is it not? Yes.
Then five. 32.
2 weeks. This. 2 weeks. That's the request of.
My lord, item 26. I am for the OP and the petitioner is also present.
I am for the appellant.
My lord,
Senior, his senior is very much ill.
You
And
will
he
grant
has also requested me to.
all right. Item number
26, my lord.
26. Matrimonial matter.
Minus.
Now 2 weeks.
My
2 weeks finally at the request of both the sides.
Then 6, 32, 32, 35.
Next.
Then 7, 36, 37.
Next.
Then 8, 38.
Page 8, item 41. I am for the appellant. My learned friend is appearing for response.
He is here.
As per order of this honorable court, my lord, both the parties appear and matter compromise is going on.
Going
Now
on.
the husband and wife, my lord, residing.
You want time?
My lord?
Do you want time?
Yes, my lord.
Well, we'll give you
1 month time, my lord.
1 month.
Yes, my lord. Residing happily, my lord, now.
Is
Both
it?
are. Yes.
Yes. Call up 4 weeks for reporting settled. Hopefully for reporting settled.
But distance since February should have filed the affidavit.
My lord, what happened now?
They still want the petition appeal to be pending or what?
Yes, my lord. There is something.
Very happy to the appeal to.
Yes, my lord. But time, my lord, there is disturbance. That's why, my lord, we are trying, my lord.
Every marriage will be like that only. Humor may not be.
Page 8, item 40, I have taken consent of the learned counsel for the respondent. I am for the
You want
appellant.
time?
Yes, yes.
When do you want?
Lordship, for a month.
1 month?
1 month.
No, we'll not grant 1 month.
As-
That is leave we cannot do.
As a lordship, please.
2 weeks. Call up for 2 weeks. At the request of. Okay. If your opponents come and mention
I've already.
that they are not informed, we will take up the matter in your absence. We can't make the lawyers to wait here. Not a happy place to sit idle. Yes.
Item 1.
Yes, sir. Yes, Mr. What is this matter about?
Order passed by the learned judge, judgment passed by the learned judge, family court, no? Judge family court, Rourkela is under challenge.
Can you use mic? Because there are law students who are telling that your voice is not audible.
No, I can speak loudly, man. I can speak loudly.
Yes.
Lord, the judgment passed by the learned judge, family court, Rourkela is under challenge. The wife, the so-called wife, respond number 1 and the daughter, both of them filed application on section 18 and 20, claiming maintenance. The respond number 1 claimed that she is the wife. 2 claimed that 2. I'm so sorry. Respond number 2 claimed that she is the wife. She is the wife, and 1 claimed that she is the daughter. 18 and 20. 18 is for wife, 20 is for children, legitimate or illegitimate, whatever the case may be.
No, whatever. What they have said. What was your stand?
The learned judge family court in the impugned judgment has said that the respond number 2 is not the legally married wife. So she is not entitled to win. But that's what the finding. No cross objection is against system.
In matters pertaining to maintenance alone, how the claim for marriage or justification decree is approached by the
That she has admitted that there is no marriage.
She has admitted. Show that admission.
That's the finding.
Show that admission.
Para 7.
No, not the, that's the version of the
In the
judge.
finding, it is there, she has admitted.
Now you have to show where she. You are for the wife now, wife and child.
No.
You are for the
I'm
husband.
for the husband.
Where is that finding?
Kindly see internal page 7, para 7. Bottom 3 lines.
7 page.
Bottom 3 lines.
So how the question is how he arrived at that conclusion? What was the material before the judge?
See, Lord,
To
see,
conclude in
but
a
this judgment
maintenance
is,
proceeding.
wife is not
There
challenging.
is marriage.
Wife is not challenging this.
Could be.
That
We're in appeal actually. The difficulty is that
No, husband is in appeal against the child. Against the
we are
daughter.
hearing that appeal.
now
Can be.
Are your lordship proposing to vary even the finding against the wife here in this appeal? But in that case, I will be allowed to withdraw them.
well, if you say, then we withdraw that. But do you make that submission?
Lordship may say that with this observation that your lordship wanted to intervene in the wife finding.
No. It's not a question of wanting. Since you are addressing us.
Lord, I am addressing only confining to the daughter, that's all.
No. It is
One
not there.
second.
That is.
1 second.
Right, you have to allow us to speak something.
1 second. 1 second. In the matrimonial proceedings, these are participatory proceedings. They are not just husband and wife. Court is the guardian.
Right.
Under the doctrine of parent patria,
Right.
court is a doctrine. In that doctrine, court is also a part of the proceedings now. That's how approach of the court is now. Or good olden days, yes, husband, wife, etc., well and good. Now it is not like that. Because it's a social justice statutes. Therefore, court will have a role to play. Therefore, courts grant more maintenance than what is claimed.
Let me place my points.
Right.
Your lordship.
Your first point is,
My first point is that I am challenging this judgment with regard to awarding maintenance
yes,
in favor of respondent number 1.
yes,
But though I am challenging this
Yes.
judgment, without recording my concession, I find that Lord, your lordship may not record my concession.
well, very, very, no issue.
That Lord, the court is justified in allowing that in favor of legitimate or illegitimate. May not record my concession.
Just look at para 5 since you are contending because the basis of not granting the C is there. C suppose say that C doesn't oppose anything, C doesn't require any internal page 7 of the judgment.
Right, my lord.
Above para 6.
Right, my lord.
The petitioner number 1 has given birth to the petitioner number 2.
Right.
Just kindly read that.
Petition number 2 on 20.
Your Lordship.
Yes, sir.
In item number 6, Your Lordship, may kindly have a glance at the last order. Last 5/2025.
My lord, I'm sorry. Can it be one pass over? I'm just coming. One pass.
Get your pen from. Pass over.
He mentioned after he reaches. Please take that.
That. Yes.
But in this case, I am for the petitioner, madam.
Yeah.
The petitioner challenging the order of Central Administrative Tribunal dated 14/1/2005 passed by the ordinance in OA number 429 of 2023.
Yes.
The caveat petition, my lord. The last occasion it was listed before Honorable Mr. Sahoo.
So I said, we have said an order.
That past order to serve a copy. Therefore, as you are the party in the proceeding, therefore, I require only a copy before.
I have already said the copy. Let them.
Just giving a copy.
No.
Now, I have filed a caveat petition. I don't know what
You want time? We'll grant you time.
Next week, my lord.
He could have paid for that because what after.
Anyway, do you want time? We are granting time to you.
Yes, sir. Come up after 1 week.
Call next week at the request of learned senior advocate appearing for respondent employment. Yes.
Item 10.
Yes, sir.
Then, my lord, decision appeal, appeal.
हाँ
उस इवेंट को handler आके जाए the same was dismissed on the ground of delay, then the state government has moved to the Honorable Apex Tribunal. There when the same was condoned, may I take the leave to support. Copy was there, but additional copy.
It's there in the list.
If in the reference. Now what it says in just 2 lines, what the Apex Court said.
And in view of the judgment, in another...
all right, what it said ultimately?
To condone the delay and remitted back the matter.
It condoned the delay?
Yes, sir.
So we have to take up the matter on merits now.
Exactly.
Argue.
155 days delay.
Delay?
Yes.
We have to condone the delay. There is a direction like that. Read it.
The impugned order of the division bench of the Honorable High Court refuses to condone the delay of 155 days in presentation of the inter-court appeal by the appellant state of Odisha for the reasons indicated in the civil appeal number such and such. This civil appeal, who stands allowed.
What are the similar directions?
My lord, similar direction is at the next page.
Next page.
It is in case of Atal Bihari Manji, state of Odisha. There in 129 days delay.
Flag F click करो तो अपन ने सब देख मैनेज करो इसको working.
In that case, 129 delay was there, my lord, in presenting the intra-court appeal. Or proving hard regards to the fact on the
plota. Or translate click करो तो.
Brother, in view of Apex Court order, perhaps you have to be a bit lenient in condoning delay now. Court has remanded the matter for consideration of fresh. Correct.
But delay has not been condoned.
We will condone.
Only the matter has been remanded.
That's what. Yes, that's what. But remanded because Apex Court found fault with the coordinate bench in not condoning delay. Therefore, we will condone delay, subject to payment of some cost to you.
Now, Your Lordship, before that, kindly have a glance at order 13/4/23.
So, Mr.
That is set aside now.
Mr. Behra, the Supreme Court says that
that order is set aside.
Look at your appeal. That is SLP 27402. Badrinarayan Rao.
Yes, sir.
So look at, read it. So you are just guessing it and para 3.
For the regions.
For register.
Kindly read.
For the reasons indicated
nodding head is nobody is reading.
For the reasons indicated in the order on the civil appeal arising out of SLP number 26359/23, the civil appeals to stand allowed.
Slowly, to stands allowed with similar directions observations.
And in Atal Bihari.
So Atal Bihari is very clear in condoning delay. That's that is what fell from my lord.
Relevant para is para
5.
Provided court shall stand revived.
All right. What is the reason shown for condonation of delay?
Because, my lord, the official in process it was delayed, my lord, 155 days.
Then you pay 5,000 rupees cost. This intra-court appeal is filed after broking a delay of 155 days.
5,000 is nothing for state.
A coordinate bench of this court, by the order dated.
Order dated, sir.
It is, my lord, order dated.
This appeal, nothing.
Milord 17 order number 5
had rejected application or rejected application for condonation of delay, and as a consequence, appeal 2 was first. Matter went in SLP number 7202 of 2023. The Apex Court, when the order dated 11/11/2024, having set it normal, the coordinate bench's order has remanded the matter for consideration of which. First, look at the State Council appearing for the government state submits that There is a plausible explanation for the delay group, and therefore the same be accepted and delay beacon. First, learned counsel representing the respondent makes contrast location and seeks dismissal of the application for termination of delay, and as a consequence, the appeal has come. First, next one. Having heard both the sides, whereof the considered be that in the official administrative process, in matters like this, ordinarily delay would be proved, subject to all the strings. First, there is a plausible explanation for the delay of 155 days that happened with preparing the appeal. First, a proud condonation of delay would not add merits to the case of opponent to the prejudice of response. First, older matters than these, this are still pending in the court province. First, the non-condonation of delay was ordered by the Apex Court of the countries. First, next one, the host of the application is favored and delay is condoned, subject to the condition that the appellant shall pay a sum of ₹5,000 to the respondent. Which respondent? For this one, sole respondent.
Sole respondent.
Sole respondent.
The respondent within 2 weeks. Within 2 weeks. First, this amount shall be recovered after payment, from the erring officials of the government, and report in that connection will be filed in this court when the main matter is taken up for admission. On that admission, this money we cannot give. You should point out who is the erring official, recover that money from him, and make a report to us. Otherwise, that order will be kept in cold storage, and citizens have to pay for the fault of the erring official.
We may say, we may pay it.
No. You have to pay. You cannot pay the public money. There is one who is responsible for this, recover it from his pocket and report to us. Report to us on the next date of hearing.
You pay it and report it from your servants.
मतलब that observation में
No.
We're conscious, my lord. I go down, but so far the remarks they may suffer.
That what suffering? What money should be from? The official shall not be treated as statement.
The matter will be listed.
It will be listed for this one. Within 2 weeks, you have to make the payment. In the event, if again delay is proved in making the payment.
My lord, it's not required. We'll make it. We'll go down to you.
You also fix a date, man.
You should please prepare on release. And then started with if KRISHNA.
That is not about yes.
Invitations in the field orders. There will be many the office. But before that, there is an order that the respondent never applied for the post, and he did not file that affidavit.
They have filed an affidavit. I have also filed the reply to the affidavit. Only stand is that since the petitioner has not, respondent has not faced any recruitment, even though the treasury officer has himself written to the director.
The problem is that we should have taken care that his matter is because of the merits. Because next day, will be ready.
Yes, on 13/4/23 order for a moment, kindly have a glance.
So right now we are
yes. In that case, in similar case, they have already implemented.
I have not asked you to address us. I'm saying something else.
Yes.
Next. Item 11. So the next day you have to recover that. Next time, cost will be levied. Time is on.
I can do it. I think your is for 0 is your applicability. You need everything for 0 please.
No. This is item 11, this is item 12. Next item. Here, my delay is of 77 days.
70. Notices to go.
Notices to go.
What the matter already?
This is
Work content.
this is regarding appointment of Shiksha Sevi Shiksha Sahai. Initially, in 2003, she was engaged on consolidated of 1,500 crore. Then subsequently, while he was working as such, 17 students from the class of 4th to 6th, they have been deputed for his personal work.
Cattle puja.
Cattle, cattle together. Plucking of flowers which was cultivated by the teacher concerned. I mean to say the respondent concerned. So subsequently they have been found out. Then referred to the CWC, was recovered and rescued 17 children. Inquiry authority was found out and finally it was ascertained that it is true. Then proceeding was there. But while considering this Hon'Ble single bench, by the order dated 14/5/2024 was the order and allowed him to join in service, even without considering the factual aspect and what has been raised in the counter itself.
Emergent notice.
Let that delay be continued.
Well, notice has to
Notice.
is complete. Good. And then
They were recovered from the field itself.
Field itself by the CWC 17. Which is
8 kilometers. 8 kilometers.
8 kilometers. I'm sorry.
Yes, it's around 8. That's not bad. Then, next.
Item 13.
13 here, my lord, that the contractual workers and the worker.
We have posted a similar matter.
7/7. May pray.
Emergent notice in the meantime.
Yes, ma'am.
Issue emergent notice. And if service of notice is done in the meanwhile, call this matter on 7/7/2020.
Sole respondent.
Sole respondent. 2025. Along with connected matters. If any. Yes. Yes.
Order dated.
Single judge's order.
31/2025. 10 January 2020.
Yes, sir.
Maybe.
His number. Yes.
And this is kind of an advocate I did on behalf of that. There is something which grant is agreed by judgment dated 30th July 2000.
That's all right. What are the faults in the order?
My lord, all the fault is that, my lord, the interpretation of 48(2)(b) of the certified standing order.
Let us see that.
Yes.
Under Standing Order Act 1946.
No, it is, my lord, Sahoo Officer Service Regulations, my lord. It is quoted in the
Paragraph, page number.
my
Read felt equivalent.
Which page, which paragraph? Can we ask our registrar? Is it not part of?
Yes, sir. Did you annex that to the writ petition?
Yes, my lord.
Annex, sir?
Brother, these things are basic things. On this we cannot spend time of the court. We are, this is now 11:45 and we are at serial number 14:15. By now at least 35 matters would have been over.
We have given it in a written note, my lord.
Now give us at least supply that. No, if you have a copy.
That is dated. That is dated.
But I think we have given it.
So that standing order dated.
Standing order, my lord. This one I am getting.
Sumanti, you filed a standing order?
This is in fact the CESCO officer service regulation. That regulation, the TPCODL is now following that. That is a certified standing order. There is a printed book.
Correct, if you have filed it, so I can look at it. So that's the only thing.
But I have not filed it.
What is
The regulation.
Yeah.
ये बंद कैसे हो गया?
Part you are aggrieved.
My lord, I am agreed with the 64 my lord.
Which part of now you have been exonerated?
Yes, sir.
And
My lord, my
part 3.
Yes, my lord.
Item 3, dismissal period connected to is treated as without pay and allowance.
Yes, ma'am.
Period of suspension.
Who also
Period of suspension.
Written as a new
regular what? Languages.
Correct.
Period of suspension is related to the necessary particular.
What is it?
Lord, before Lord, that is the technicalities of law, Lord.
Not technicality,
Lord,
substance of law.
Lord, I'm coming to the background of the case, Lord. Initially, the major punishment was imposed and the petitioner or appellant was dismissed from service.
Manti, he was a very bad person.
But you have given a certificate.
You have decorated him.
You have decorated.
So please don't
see the revision order.
make us to look in a different way other than you what you have said.
I have to let that is no. That is no.
Actually, you have a problem. If you start submitting in live court proceeding, which is also telecast live, is a problem.
That is the background of the case.
No, it is not background.
Every background will go to the background because of this order. As my brother said it rightly, metaphorically, you have decorated him.
No, that is there. Then you will kindly see the subsequent revisional order of page 74. No?
This order was carried in revision.
Yes.
Then where is that?
That is at page 74.
74.
What it says?
It says that, my lord,
The committee opined that
I'm reading that.
1 and 2. Last part.
Divisional order.
Last part.
Last part is the operating one.
Suspension period shall be treated as leave due and admissible.
And he has given some prospective financial benefits. But the observation made in the second part of the order will also kindly see.
This revision was by the employee.
Yes, Lord.
That was by employee only.
Yes.
That is the
I went before the.
No, brother, you can't say what's happening. Therefore, he is complete.
So you are arguing for him or against him?
Lord, this is the part
See,
of
the problem, Mr. Mohanty, that the revisional order shows the bias.
Yes.
That it is
complete exoneration.
Yes.
How can you deny the benefit?
Suppose you would have challenged if there is a provision. Then it can be a negative order, an order against the employee can be passed.
That is a provision, I cannot wriggle out from that.
No, it's not a question of wriggling out.
But that I cannot dispute even, Lord.
May I repeat so that you can, or if you know what I have to
I will not say.
Sir, this revision was filed by the employee or the employer?
By the employee, Lord.
Yes. So in the revision filed by the employee, can the employer pass the orders against the employee?
No, Lord.
So then it
is a confirmed order. Lord, that I cannot dispute, Lord. Only thing I want to point out is
suppose there is a provision that you can pass, then you have to bring it to our notice. Yes.
Well,
the divisional authority has the power to pass any order anytime.
That
in any
provision is not there, Lord. That provision, suppose the appellant petitioner, Lord, that I can't dispute is a provision, Lord. Only thing I want to point out the observation by the divisional authority, Lord, how the subsequent de novo inquiry, the charges could not be established because of.
That's the point now. We have to well taken. Then next point is.
Well, that is the point, Lord. That is the point because of delay of 10 years around, Lord, I prepared a note of submission and also the death chart, Lord.
How many years he was away from service?
It was
around, Lord.
From which date to which date? These are the service matters. You should come with statistical data. You are turning the pages in the open court. That's not a happy thing. Everybody is looking at you now in the online.
From 26/2000, my lord, till my lord to 4/2/2009.
Give us the foundational facts, sir. The first order, exoneration order is dated?
First exoneration order, my lord. 14, my lord. Page 14, my lord.
We're asking the date. We're asking the date. Dated what?
This is my lord 29/2010 months.
29/20.
September 2010.
September 2010. You were exonerated. Then the revision order is dated.
Revisional order is my lord.
27/10/2016.
This in Sanskrit is called Yuddha Kale Shastrabhyase.
My lord, 27/10/2016.
27/10/2016.
2016. All right. Then single judge.
Single judge order, my lord. My lord, on the 31/7/2020.
Now, last question we're asking. Ordinarily, in public service, no work, no pay. Ordinarily. When they are at fault, then it's an exception. That whole everything has to be paid. Now we are asking you, before taking a decision, we have, this is an intra-court appeal. Our powers are very, very restricted. We are asking you, are you ready to walk a few miles towards the employer? Because in the event we reject your appeal, of course, you may succeed in the apex court also, we don't know. But what happens here? Again, another 5 years. Instead, go for a bargain. Go for a bargain. We'll make it a court order because he cannot agree for the bargain.
My lord,
Your instructing counsel appears to be wiser.
my lord, actually, this is a transfer bill. That is the whole problem.
Very
what has happened, my lord, he is now retired, my lord. He's
Retired.
from service.
Therefore, our proposal. Now we have to travel in the evening of life.
My lord, I think we will go for the bargain.
That appears to be, that's a good thing. Yes, tell us. There is one famous poem by Robert Frost.
Miles to
Miles to go before I sleep, miles to go before I sleep. Yes, before I sleep in the grave it is. So we have to watch.
We have to make and we'll give that. What amount we want to take, my lord, we'll
No, what we got to say. Take instruction. So we cannot give time like that. Otherwise,
So, Mr. Patnaik, you must be clear that whether you have lost anything in pension.
no,
By fixation of
he will not. He will not.
You should not. So we will be clear on that because you lose this opportunity. So if you have bought everything, then he will reconsider this. Yes, Mr. Mahanti, you pay him something lump sum?
Yes, sir.
Very pass over.
Want to pass over?
Very pass over.
You conducted a diploma in India state.
But in fact, there is a direction from this court to the appellate stage, my lord, to go for further proceeding, my lord.
No, I could not get you, sir. De novo inquiry, when you conducted, after the final order was passed, there was a remand or?
Yes, there was a remand from this court. After the final order of dismissal, there was a remand from
this order is post de novo inquiry?
Yes.
Post second order. It's a second order.
Dismissal order, subsequently,
So you also, Robert Frost, that poem I remember, I said that 3-4 lines, very beautiful poem. When Jawaharlal Nehru died, he was holding that book. In fact, Robert Frost, woods are lovely, dark and deep, but I have promises to keep. Miles to go before I sleep, and miles to go before I sleep. So miles, some few miles you have to walk now. Come after that. Very famous poem is of the Eagles. Yes, sir.
This is a matter regarding selection of a junior engineer civil. And the matter is a hearing impaired person who has submitted application for delay. There is delay.
Served. Will condone delay.
No. Let us copy of the I have already appeared. My name does not reflected in the call.
Not reflected. But you are here. You knew.
Let him solve a copy of the
I will solve.
You copy.
I will solve. Both the repetition and calibration both.
Solve this matter day after tomorrow at the request of both the sides. First off, in the meanwhile, all copies of, including IA, etc., to be served by the counsel for the appellant to the learned counsel representing the opposite parties. Yes.
Okay. It's an intra-court appeal. But so far the judgment is concerned, this has been challenged by the present respondent, so also the appellant.
Both have challenged.
Both have challenged.
What is that grievance? What is your grievance? What is his grievance?
The basic grievance is the person who has challenged the same. So far the state government is concerned, 4 persons of ECG operator was appointed under the SCB Medical College by virtue of an advertisement. The present respondent, they have been, apart from the advertisement, they have been engaged in 2011 on contractual basis.
In addition to 4?
Yes, exactly.
He is 5th one.
Under the Swasthya Seva Samiti, not by virtue of this advertisement.
When that happened?
You can check the facts. It reads it happened in post advertisement. Since you are introducing it, so
first advertisement of 2010. Second advertisement was 2015. Prior to that,
these persons were appointed without being without being advertised.
Yes.
That is your contention.
Yes.
So that is not there in the writ petition or your contention also.
I'm coming now.
Show your objections.
Yes.
In your objections to the writ petition.
My objection so far the counter is concerned in the writ. Can have a glance.
Page number?
It is mannered running page 101.
So what is your answer to annexure 15? Straight away go there.
I have answered Annexure 15. Annexure 15.
Page 104.
Sorry, Annexure 1 rather. Annexure 1.
The advertisement at internal page 20 minutes.
Then, in case we go to
2011.
when you came to know this is all wrong.
With your lordship, issue your lordship is asking. Issue is, of course, the judgment is a very lengthy judgment, but of course, ultimately consideration was there. Fact remains, and that is also the admitted case of the respondents, opposite party. But way back in 2011, pursuant to an advertisement, they were selected, having the requisite qualifications. Yes. In
Your name did not figure in the select list.
No, that is exact. That is admitted fact, and they have not challenged that judgment. Yes, sir. Sure. That will you also look to the judgment itself? Because they have not challenged. I accept the judgment. After we can straight away go to the annexure. Yes, no. Yes. I'm okay, sir. That's first case. Let us, yes. Yes, that is WA number 3071 of 2023. I'm sorry, but there are two of them.
Sure.
Yes. That's it. Yes, this one. List of candidates for selection. Yes, that is 3071 of 2023.
3071 is the rate of fee.
Rate of fee. Yes. So kindly look to page 19. No, yes. This is the advertisement. Yes, advertisement.
So this participated in the recruitment process.
Yes, sir. My name is also kindly come to page 20. Serial number 1 and 6. Ganesh Chandra Bhuya and Deepak Kumar Naik. Yes. List of candidate selection for the post of ECG technician. ECG technician. Then you also kindly come to page 21, annexure 3. The selection committee consisting of 7 persons. Yes. Then you also kindly come to page 22. Annexure 4. This is in pursuance of the decisions, this is 11 to 29/4/2011 by the superintendent of SC Medical College Hospital, Cuttack on the basis of the decision of the selection committee. In pursuance of the decision taken in so and so committee held on such and such date, and as per the decision of the selection committee held on 28/4/2011, the following candidates are appointed as ECG technician in cardiology department of this hospital on contractual basis, with the remuneration of 5,200 per month from the date of joining the post. Their monthly remuneration will be made out of Swansu. You also kindly come to 1 is Ganesh Chandra Bhuya, the petition number 1, and 3 is Deepak Kumar Naik, petition number Two.
What happened to Dhaniram?
Dhaniram, I don't know what about him.
They are not before the court.
They are not before the court. If your lordship will then
What is the response? In fact, there we stopped. We were asking Mr. Mohanty that what is the response to Annexure 3 for all these advertisements?
They say that
your first submission that they were not selected, it will fall to the ground. There is abundant material to show. A selection committee comprising of 7 members, they selected these people along with others, and subsequently all records have been verified. Then the appointment order on contract basis has been granted. Where is the fault in that?
At the cost of repetition, my humble submission, I will reiterate the same page once again. Page 19.
One nice.
Yes, this is annexure 1 to the writ application.
Yeah.
Now, what it is? This is an advertisement for inviting application for the following post for engagement in trauma care center of SCB Medical College Hospital on contractual basis.
But appointment is to which post?
My lord, I am coming at serial number 3. One is pharmacist, second is X-ray technician, third is ECG technician. We are concerned with the ECG technician.
But they are appointed, engaged on what?
I am coming to the next. The next page, that has been read out by my learned senior. It is page 20. The candidates, those who have applied for. Then coming to the annexure 3. Once again, I am referring. The proceeding of the meeting for engagement of ECG technician on contractual basis from the user fund held on 28/4/2011. The advertisement of 2010 for the 4 posts. That has completed. Then second, my lord, so far the annexure 3 is concerned, the meeting was convened on 24.
Mr. Mohanty, they are not saying that they are selected in 2010. Your problem is that you are shifting the goalpost. See, they say that they were selected in whatever process in 2011. You are saying there was advertisement in 2010, they are not selected. So that doesn't answer that court's query nor the factual position. You straight away, without shifting the goalpost, straight away answer it. Catch the bull by her.
Page 23.
Page 22.
22.
22. Annexure 4.
That is a committee.
In pursuance to the decision taken in Swasthya Vikas Samiti held on 14/1/2011 and as per the decision of the selection committee dated 28/4/2011, the following candidates are appointed as ECG technician in cardiology department in the hospital on contractual basis with a remuneration of rupees 5,200 per month from the date of joining to the post. Their monthly remuneration will be made from the user funds. Their appointment are purely temporary and can be terminated at any time without prior notice and assigning any reasons. Yes. Then serial number 1, 2, and 3. So far 1 is concerned, this is before my lords. So using the user's fund, because what happened, the state government while making and collecting the user funds for different tests in SCB Medical College, out of that income, these persons are being paid in order to mitigate the problem. So far the 3 persons have been engaged.
Attention that source of fund will matter as far as regularization is concerned.
Oh my Lord, I'm not.
So please, so let us have a courtroom or deliberation. I mean, not.
I'm coming to the next one.
So straight away come to the best point.
Another advertisement was searched for the another 3 to 4 posts. So far the ECG operator is concerned. That is also under challenge. That has been taken care of while disposing by the Honorable Single Judge. Finalizing the same, the 2 successive writ applications which have been filed by the present respondent, number 1 and 2, they have withdrawn the same. Only so far the application for regularization for consideration is concerned, that is kept pending and direction was given to consider the same. Our grievance is, so far the contention of my submission is, they have been purely not an advertisement on contractual and the amount which is manning the post is out of that user funds.
Since my brother asked the question, whether the source of funds from which you have paid the salary, remuneration, is it relevant?
Initial appointment.
Since Manu has asked you again the same question, I will give you a further example. You take an exchange. Usually you test it with exchange. Suppose you say that the source of fund was ill-gotten money. ill-gotten money was spent for paying the remuneration. At their, yes.
Suppose they are taking some bribes in the process. That bribe amount is extremely. That money is paid by way of remuneration to these people.
Somebody
You mean to say
bribe. Suppose the superintendent received the bribe.
and makes payment.
It's a process, man.
No, it's not a process. It's not a process. You see, the remuneration at their hand. So then you have to develop cite some case law that if it is not from so and so, it is ill-gotten money, or so that's not your point also.
No, in fact, counter we have raised all these points in counter also. In counter,
No, you have to demonstrate that money paid by way of remuneration to these people is from X source, and therefore they are not entitled to the relief. That you have to show. There is one judgment by Lord Denning in deciding the contract of service in the 1940 cities. Contract for service, contract of service. How he is appointed, what is the extent of control over the employee, how the money, the remuneration is paid to him. There is one judgment of Lord Denning, our apex court as well. I read in the beginning of my judgment. Contract for service, contract of service. Lord Denning decided how the difference is when it is a contract of service. Anybody Google out that judgment present in the court hall, any intern, students, Lord Denning on contract of service. There is such a judgment. Just Google out. Any student on the last bench? Lord Alfred Denning on contract of service and contract for service. And our apex court followed that judgment in 1960s. What is it?
Mahanti, you make a legally tenable best point. So that interests everyone. So that they will answer, court will also respond.
Bring both you bring that judgment.
Yes,
Both you bring that
certainly.
judgment.
But here, so out of the court. So, but the state of Orissa is concerned, they have made a rule, 2013, where they said that notwithstanding anything contrary to any law, this will prevail all over the law. They said that all appointment to the civil post, Group C and Group D, that will be made on contractual basis in terms of that rule. Okay. And after completion of 6 years of service, they are deemed to have been no further order is necessary. Only formal order.
Deeming
yes.
Deemed to be what?
Yes, deemed to have been regularized.
Okay. Then what remains? If that is so, if that is the rule, by which rule? Can you read that rule? This rule is not there in the state from which I read.
Exactly, I wanted to just bring to that.
If that is the rule position, what is the case for you?
Group C, Group D, post contractual, appointment.
The rule is heavily loaded against you. Kindly come to that. Which is that?
Yes, sir. Rule 10.
Rule 10.
Regular appointment. On the date of satisfactory completion of 6 years of contractual service under sub-rule 1 of Rule 9, they shall be deemed to have been regularly appointed. A formal order of regular appointment shall be issued by the appointing authority. That is Rule 10(1).
No, 6 years of contractual service.
Yes, sir.
What is meant by
contractual service? Means they must have been appointed on contractual basis
by the competent authority.
By the competent.
Is it defined?
That has been defined. Rule 5 will also look. That is a provision. Recruitment procedure. Recruitment to the post shall be made on the basis of the provision relevant to recruitment rule or executive instruction, or the case may be in force, notwithstanding anything contrary to the contained in the relevant recruitment rule or executive instruction, as the case may be in force. All appointment made pursuant to sub-rule 1 shall form from the date of commencement of the rule be on contractual basis. All appointment to be treated as a contractual basis.
Page 49 amendment.
And the page 39, you also look to that. Now, this rule, 13 rule has been amended in 2017. And they say, which they have carried out in this case. You should also look to page 49, the second page. They have made this rule amended in 2017. Particularly the remuneration of the contractual employee, which they have complied with in the present case. That is at page 49, annexure 17 in the second case. This 13 rule was amended. In exercise of the power conferred by the proviso of Article 309 of the Constitution of India, the Governor of Orissa is pleased to make the following rule to amend the Orissa Group C and Group D post of post-contractual appointment rule 2013, namely so and so. Trying to come to small A. Rule 9. The Orissa Group C and Group D post-contractual appointment rule 2013, even after referred to as the said rule in Rule 9, for sub-rule 2, the following sub-rules shall be substituted, namely 2.
The copy which you are now furnished. No, whether it includes
this is the rule of 2013.
Original rule.
Yeah, original. I have incorporated that 2017 rule in my writ appeal. That is in WA number.
Second one,
3071.
Page 49. Page 49.
Yes.
Annexure 17.
Group C and D post control.
This is Group C. This post is Group C.
Remuneration. In the period contractual appointment, they shall draw monthly remuneration at the rate listed in the letter appended to these as applicable to their number of completed years of service. The source of payment is not mentioned.
That is there, page 50. Treatment of table revised remuneration of contractual employee with effect from 1/1/2016.
Page
50.
The Lordship is asking whether this rule makes a distinction regarding source of payment.
It does not make.
This rule has been made applicable to
We have developed that.
Right,
That argument is not arguing, but
yes. If you also look to page 52, they have made this rule applicable to the case of the petition. But you get it?
yeah.
In pursuance of the RDC letter number so and GA department notification, this notification number 19975, dated 12/9/2017, the following ECG technician engaged in cardiology department who through SPS approval are allowed to draw the monthly remuneration of 15,320 with effect from 1/7/2019. This 15,320 will also be looked to page 50. That is the.
I mean, that is equal work, equal pay, you are saying.
No. They made in 2017 that those who are continuing on contractual basis.
They are entitled to draw
they will draw this.
40% increment above.
That will be increased.
That is after that Supreme Court judgment.
Right, sir. 52 said that referring to that amended rule, they are given this benefit. They cannot go back now say that. So,
yes, Mr. Mohanty, rule position appears to be heavily loaded against you.
So
the rule which
consequential appointment amendment rule is concerned, but in our appointment letter, so far the issue to the respondent is concerned, the source of payment is also there, which has been cleared by the Swasthya Seva Samiti.
Now, how he is concerned with from where money comes to me? I am not source. I am not bothered as long as I need not go to Gangotri to get Ganga. If I get Ganga water, if I can fetch the water from the river, it's over.
I'll clarify this situation.
Available in post office. Gangotri water is available in post office. That's the project for you. We will travel to Gangotri.
But Denning discusses this aspect also.
That I will check it out.
Nobody could get that judgment, 1946, something like that.
My lord, that this is the judgment, ma'am. Stevenson, Jordan.
Correct.
52.
Correct. Yeah, All England Report 1952.
Yes, ma'am.
52.
Just look into that judgment and come back. I look into our Supreme Court's judgment, which refers to Denning. Although House of Lords reversed that judgment, but we follow Denning's judgment, not House of Lords judgment. Of course, many of his judgments were good. His books are also great books. The first book, Landmarks of Family Story, Great works there.
Much water has flown in the meantime, so that the contractual appointment is.
That's what. Let us just look into and come back.
My lord, regarding that item 14, because he's an old man, my lord, a bit problem is there to communicate with him. He's unable to make out that what he was getting, my lord. So can it be taken up next Monday, my lord? I will come back.
Next Monday?
The details, my lord.
We'll have it. Next month you make an offer.
Yes, yes. In the meantime, I'll also make the calculation and come. Yes, yes.
Yes. Because of that, the certified standing order, once certified, the Apex Court said in Tata Oil Mills, once the standing order is certified, they partake the force of statutes.
That is the reason
under the
my
1946
submission was very fair, Lord. I was just.
That's one. That's just look into. If that is so, it is your fault. Suppose if you had not exonerated, had he not been exonerated, we would have understood. We do not fully exonerate him. However, we give him benefit, etc. Let him take shelter under the leaking umbrella. These things we would have understood. That's not the text.
I'm obliged, much.
That's what. Just look into. Yes. Tell your client also. Okay?
Yes, madam.
It is always better to go for some amicable settlement. Yes.
Next Monday.
Very good. When do you want? On Monday only we'll take that because half already discussed. Yes. No, Monday. For further hearing, can we post them for further hearing? We have heard the matter. We have understood what is. Monday. Can it be on Monday? Mr.
Monday, my lord, 7th on that matter. Let it be on 8th.
8th, we can have this. Both these matters on 8th. Thank you. Thank you so much for enlightening the court. Yes.
Patnaik, your matter on 8th. Subhanti. Yes, 7th you have already posted so many times.
Other matters are posted. Calendar is full that day. Diary is full. Therefore, on 8th we will have that. Yes.
Lord, may I pray, Lord, can it be on 9th? Lord?
9th, all right. All right. Tell your friend also. Yes. Yes, brother.
Let's prefer intercourt appeal challenging the judgment dated 11/8/2023 passed by the Honorable Single Judge Millard, where directing to decided in case of the Patitapan Das case versus State of Orissa. And that case is pending before the Honorable Supreme Court. In writ appeal, state has lost the writ appeal.
But no interim order has been granted.
No.
Then whatever happens in terms of this, we also suppose in the event you succeed there, that judgment will be may applicable to this case also. Unless earlier view was 87 Supreme Court. When a question is being debated on the floor of the apex court of the country, all courts should ordinarily await.
Number of cases regarding contractual appointment has been pending before the Supreme Court. I have given that judgment.
Correct. But where is the interim order?
Interim delay is condoned and it is posted for the admission and hearing.
Well, it will call this matter after 3 weeks. The court reopens on 4th of July, na?
Yes, ma'am.
No, my lord, I am appearing that actually, my lord, kindly see the order dated 16/5/2024. It was heard.
See that.
16/5/2024. It was heard before the my lord, that Honorable Chief Justice, and this judgment kept reserved that this will be decided and exemplary cost will be passed. This is not a case of contractual appointment. Because only that Patitapan, it is not no link with Patitapan Das case, my lord. And you rightly asked that question if whether that has been stayed. My lord, after that, on 10/1/2025, whatever may be, due to...
Yes, madam is saying something. No, you will not pass any order without hearing it.
Yes, that's why they are the petitioner, they are taking all the adventure. My lord, this is the case your lordships was quoting Robert first that it is miles to go. My client has gone miles and miles from 2007. He is fighting, my lord. My lord, his appointment is against a substantive post. He was regularized by High Power Committee in 2013. And that committee, due to that is infighting of 2 IS officers, he is suffering, my lord, because he has revoked that, recalled that regularization. Again, we have not challenged it. Thereafter, again, my lord, I am saying, before your lordship, I am fair.
Very well. You are very, very fair in making submission. We agree. We don't deny that at all. Very effectively, you have argued the matter.
Now, Lordship, kindly see, that is not a contractual, that is the first
You have
period.
to allow the judge to argue also. We also sometimes argue, na? Yeah. Now, he is saying, matter is coming up before the apex court.
No, that is no link. That's why I'm saying before your Lordship, just hear me for a moment. That Patitobandas, they are taking shelter. Where is that shelter in 16/5/2024, my lord? 16/5/2024, they have argued the matter. It is hard at length.
You have said that now. You're not.
Yes.
Mahapatra, can you just look at that order sheet in the next to you? Order number
6/5/25.
I'm saying, my lord.
You have a copy of that?
Yes, I know that order. That order.
Our memory is not as strong as you, so we have to look at the order. Look at the order of para 3.
Para 3, my lord. That is their submission, because they are the petitioner, they are getting that advantage.
Kindly read. You are not preempted from not saying anything. So please read and then say.
That's fine.
Taking note of such contention, single bench has directed, so and so.
My lord. That is my.
No, kindly look at the order.
Interim order is also.
You say that you remember. Now you say that you are not getting it.
Exactly
This bench is also a continuation of the earlier bench.
Well,
it is felt up to await finalization of the SLP.
That's not required. That I'm saying before Lordship, I can prove that.
That's always an observation. It's
Honorable Chief Justice's bench has said that.
Well, there is no, my lord, Chief Justice.
It is not against you.
Not much.
It is not.
That, my lord.
Please don't comment.
There is already.
Contention, the single bench has directed the opposite parties in the said petition to consider the case of petitioner. Now the opposite parties they consider the case of the petitioner. There is no direction. Now
Can we request you,
my lord,
to halt and proceed?
My lord.
Come to para 4 now of the said order.
It is held up to await finalization of the aforesaid SLP number such and 69.
This is the order of the bench, coordinate bench.
My lord, there is no interim order, because whatever that is
Kindly come to last paragraph.
As an interim measure, it is directed that till the next date of listing, the direction contained in the order dated 11/8/2023 passed in WP such and such shall not be given effect to. But there is no contempt is pending. But my submission before your lordship is that
the coordinate bench of this court, wide order dated 6/5/2025 had said as under. First one. At paragraph 4, the line reads like this. First one. At para 6, even interim reprieve is also granted. First up. Therefore, it is appropriate for this court to await the decision in the pending SLP number 16949 of 2023. First up. Call this matter after any of the parties report disposal of the subject SLP and not till then. Okay. Next.
Lords.
1980 Supreme Court, you said other day.
Your Lordship asked me to prepare a note. I have not given a citation. I have given citation, but photocopy has not been given. I will give a photocopy.
You mentioned other day, 1980 Supreme Court.
Yes, I have mentioned that.
That other side has to be heard in the matter. We'll have this matter next week, so that in the meanwhile you will read these papers and come back. Your notes will have been.
I will give the citation also.
Whether to leave until the other side should be heard on. This note to him, with him also, so that he can become with more weightage of this material. All right. Let's call the week after next. Tuamoto. At our side, we are taking the judgment. Yes.
I have prepared a very chart.
Yes, sir.
Relating to a premature retirement of a district judge.
One matter we are considering.
Yes.
Therefore, after that, we will take up this matter. If you permit us.
Direct to personal file had not been called for. So
in this matter.
Yes. Right.
Just can wait for that.
We'll wait.
By just keeping the storing becomes difficult. Again, we are sending that.
I know in case of Sanjay Sahoo, you have reserved the judgment. I know that.
Yeah, that's what.
And there lots of last occasion.
Triparty. In Triparty, we have reserved the matter in
Sanjay Sahoo.
Sanjay Sahoo. Yes.
Is it? Okay.
In that matter, lots of Act of State Council that whether 3 months salary in lieu of notice is suffice or not. I have given that
judgment.
Yes.
What appeals court says sufficient.
Yes. It is used in that matter also.
Okay.
Paragraph 6.
Let's go to that brief.
Which year judgment it is?
It's a
76.
Then
your 91 Supreme Court, did you see? Delhi Transport Corporation versus
yes, I have
DTC.
that as judgment.
91 Supreme Court.
I have bring that.
There it is reconsidered by larger bench. This is bench of 2.
Rajasthan State Road.
2 judges.
Yes.
But you have to read the subsequent judgment of 5 judges. I think DTC is by 5 judges.
Rajasthan Road Transport.
No, Delhi Transport Corporation versus Workmen Delhi Transport Corporation. 1990 or 91 Supreme Court. 91.
It's a.
This is a very old judgment. No? This is 76 Supreme Court, 2 judges. But 5 judges have decided that. Just look into.
Here, just a minute. Here is a case, it may be a little bit different. Here is the case, he was, while continuing as a district judge, so far the CCR is concerned, there is no adverse remark. So far integrity is concerned, there is no adverse, nothing. That is also admitted in the counter. Only plea taken in the counter is that while petitioner was continuing as a district judge, Marganj, he had given upgraded one post in terms of the decision of that committee, SETI Commission report. And SETI Commission report's judgment was directed to be implemented. District Judge Cuttack has implemented it. And some stenographer of my district, they made the representation, considering the representation that was in terms of the SETI Commission report, that was revised. That is the only allegation.
Not one post. It's a 19 post, 12 post. That is the number of posts. Without Miller's, Miller District so much did it, and without referring the DPC, Department.
The only question for consideration before FCP, they say, they have referred to one candidate, they say, that without calling for or convening a meeting, DPC meeting, whether they can upgrade. Now the question is, even as the successor, after he joined, he recalled that order. But again, he has also given the same benefit, but the petitioner has given same benefit to him.
The other district?
Yes, the same district. In my district, my successor who had come, he has given the same benefit of upgradation to those employees.
Which you had given.
Yes. Admitted fact. These are admitted fact. Nothing else.
The commission is concerned, Millard. Supreme straight to the High Court.
And moreover, they issued a show cause. I gave my show cause, ignoring that they have premature retirement. They passed the order.
That is after 55.
That is after attending as a 50.
50.
Yeah.
That is Rule 44 or something
yes,
like that.
Yes. So if you have issued a show cause, you could have initiated the proceeding, that's a different question. But immediately you exercise the power of Rule 34 and passed an order of premature retirement. That's the only question. And the same benefit I had given.
You have said that twice.
Yes, sir.
Your successor also has
given. And that has been accepted. And other district judges, including Cuttack district judge, has also given the same benefit, same, without DPC. And admitted. This is the entire case.
That is the by letter of the High Court.
The High Court issued a letter subsequently that after this event was occurred and that after the decision was taken, subsequently that without make a DPC then give it. But prior to that,
as against the successor of the respondent, whether any action is taken.
So it's a pursuant to the direction.
It's a pursuant to DPC. Unlike in his case.
DPC only.
No, sir, no DPC has been held. That is my specific case. You have not answered.
Upgradation DPC.
Not that required. That is also required.
Sir, what we will
One
do is,
stenographer has been censored
1 second.
twice and he has given an upgrade.
All right, 1 second. We will decide this matter.
Right.
We'll call this matter after pronouncing the judgment.
Right.
Maybe shortly we'll pronounce all this.
Yes.
We call this matter after 2 weeks.
I don't
Cited that judgment in another case. Yes.
Yes, I
Because it's been issued.
That's it.
Right.
Yes. That's the constitution.
Just looking to that.
Miller's, I prefer to file counter Miller's style. This two accept. One.
2023.
Yes, Miller's, after notice, it was come first time.
The state council in or very link to right to file one stand for people. Police.
Madam,
that is
Actual matter, my presence.
31.
For the accountant.
For the time of your agree. Because
For and tech. Standing on.
Some youngsters give some space for that gentle lady. Youngsters should give place to the others. I understand. That's the culture of this country. After giving to sit down, we have been seeing those standing in bed. And then back to yeah.
Item 32 and for the appellant.
Yes, sir. What is this matter about?
This rate appeal has been filed challenging the impugned order of the learned single judge wherein regulation of the employees were granted. The other party is appearing, but it is not filed in.
So it's part in the order. Collecting in the order.
Prosthetic lacuna is at the service of the respondent. If learned single judge considers it to be irregular, but as per our contention, it is an illegal one. There has been no advertisement. There has been no posts that are vacant in which the present respondent could be put into. So, Lordship.
How this contention is treated by the other critical?
Noted. So, it has not been dealt with.
Not definitely. Contention is able to make. It's not true. How can? No, it's not. It's not. The signature of the instance. The counter was made. Yes, no. Where is it going to contention?
Lord, publication 12794 of 2015. That's all. Vijay Kumar Sama.
794 Where have you taken up the contention in your government?
Yes, Lord.
Then where have you taken up the
Lord, page 3, paragraph 5. In my additional counter affidavit filed on 10th of May 23.
Learned judge have not treated that.
No, no. I'll take the lordship to that the impugn judgment. No.
I have not filed any. There are 6 matters. Let it come next week any day. Let it come. This matter. These matters. Of these matters. There are also other matters around 30 number of writ applications. AA is pending along with the list of cases. He can give it. Which appellant shall furnish to the list. In all cases, same matter, same common fund. 23. 23, lots. So synopsis.
Yes, Lord.
Point of law, which you want to learn.
Yes, Lord.
Rulings of High Court.
Yes, Lord.
With a copy. Yes. A copy of the selection.
But I will.
Yes.
I'll give 3 number of the rate appeal.
But there are 27 rate appeals filed.
So I'll give the entire list. All of those men. Because I made the order. So that's the council there.
Yes, Lord. But so I'll
Yes.
yes,
Only on the respect of 3 rate appeal. I'll give the number.
I will give it all. Yes. Please imprimand to continue.
Lordship, I am in virtual mode. On 16/5/2025, Your Lordship has directed to consider my PRC Pharmacy Education Regulatory Charges for the preceding academic session and adjust it in the current academic session. Your Lordship, kindly have a glance at the order. It is 16/5/2025, Your Lordship.
I received an instruction, my lord, and Pharmacy Council of India, and they have given instruction. This I want to file an affidavit. Lordship, give us some time because they have been given instruction.
What is that instruction?
Yes, I am just enlightening, my lord. In light of the above, expeditiously clarified in the PCI circular dated 14/12/2023 that the fees once paid are not refundable. Moreover, the absence of the required statutory documents, particularly those from the relevant state government or examining authority, the council is unable to process with the inspection or further processing of the application. Consequently, no adjustment or carry forward of the fees to the next academic session is permissible. That is circulated 14/12/2023.
Essentially, this is a case for a refund or appropriation of that money if we paid.
No, Your Lordship. No. Initially, this matter has become infructuous. On 9/5/2025, I prayed before this Honorable Court that my inspection fee, whatever I have paid.
How much you had paid?
3,54,000, Your Lordship.
This was paid on which date?
In the preceding academic session, I need to obtain the instruction of the J8, Your Lordship.
Right.
But it has already been paid. Now the preceding, I made a request before this Honorable Court to adjust that 3,54,000 in the current academic session of 2025-26 while considering my application for approval of this session. Now,
1 second. This 3.54 was paid for approval for the academic year?
24-25, Your Lordship. Preceding academic session.
24-25.
Your Lordship.
Did they conduct the exercise? For granting approval?
No, Your Lordship.
There is some exercise which they
No, Your Lordship. They haven't intimated us regarding the rejection of approval. What they have done is, after this Honorable Court passed an order on 19/5/2025, on 26/6/2025, they have intimated us that your approval has been rejected. I want to bring you to your attention, Lordship, this affidavit I am filing in the course. Two affidavits. I have already served the copy to my learned senior.
Which is that rule which provides for levy of fee?
Your Lordship, I'm coming to that.
You have to say now only.
Your Lordship,
Not
Your Lordship, may kindly come to the annexure 14 series, Your Lordship. That is the
14.
communication which is made by the PCI.
We are asking you,
Your Lordship.
Apex Court differentiated between tax, fee, fine, and such other things.
Your Lordship.
Is it not?
Your Lordship.
Fee should have quid pro quo element. Then only it is fee.
Your Lordship.
So we are asking you, under which rule this fee is leviable?
Under Your Lordship, there is a notification.
Which is that?
Notification I have annexed it, Your Lordship. Annexure 15, Your Lordship, which commences from page 26. In the additional affidavit, which I have filed.
Just filing right now.
Filing right now.
That means
Page 26, Your Lordship.
Which is the judgment of the Apex Court. We differentiated between fee and tax. Lakshmindra Tirtha Swami R versus Hindu Endowment Religious Commissioner Madras. 54, 55 Supreme Court. Can anybody Google out? Fee and tax. I think Sanjeev Cook versus Union of India. These two judgments decided that. To say fee, there should be quid pro quo services. Only then they can collect it. We are saying in your favor, since you have come without preparation. Chinnapalli judgment. Do you want to prepare and argue? Or you want to argue right now?
I have to go through the judgment.
All this matter.
Tomorrow it possible.
You have to answer that question. Judgments go against you.
I will examine, my lord, but what I'm praying, my lord.
That makes no sense.
Also, Mr. Padi, your instruction is not that pursuant to deposit, as it fell from my lord, you have not inspected.
Where have you inspected?
No, my lord. There is a direction last occasion. Lordship may see the direction.
That's all right.
Yes.
Did you reject application for grant of approval after undertaking the exercise?
No, my lord. Here is the case. He has to submit proper application. After examination, the inspection given. That's why.
Therefore, you did not conduct the inspection.
My lord,
then how can you retain that money?
My lord, you just see Lordship's notification that is cited to. There is a specific. Just a minute. I am just highlighting, my lord. Just I am ready. That inspection section. It is also informed that
54 Supreme Court. Correct. Lakshmindra Tirtha Swami R versus Hindu Religious Endowment Commissioner, Madras. The Constitution bench. There are 4 judges or 5 judges? Patanjali Shastri was 7 judges. Apex Court said that. Therefore, you have to come with preparation. You are a standing counsel. Of course, every counsel will stand and argue with another thing. That will not give you wisdom and virtue. Wisdom, virtue, knowledge, they do not come to anyone ex officio. They will come only by toiling. Both the sides to come with more preparation. And therefore, call this matter on 23rd.
The affidavit
copies of Your Worship. But I have to serve.
I'm not accept the copy, my lord. The copy has to start on me.
Just looking all those that help you. It should be jurisprudential. Saying something and going away. Nobody will be impressed.
We should feel like hearing you. We should feel when we leave the court hall, at least in the corridor, we have to discuss. Oh, this guy argued very well. We can tell the Chief Justice to consider his candidate for XYZ positions. Is it? That way you come with preparation. Whoever comes with preparation, he will not go empty-handed from our court, we assure you. Whoever comes with preparation, not saying cock and bullshit, not bringing book at all, not citing one ruling, not citing one great author of foreign country, nothing like that. That does not impress us. Okay, come with preparation. We should respect you. After hearing you, we should feel, no, we should respect him. And respecting is giving some order. Is it not? Some relief according to law. But that is not happening in this court, unfortunately. Anyways, most of the cases appear to be substandard preparations. Statutes are not brought, rules are not brought, rulings are not brought, good literature, poetry is not cited. All sterile, complete sterility. Anyway, yes.
Have to take steps.
Yes, whatever requirement is there, if you need anything to be filed, because I think court process
requisites to be complied.
Okay.
Yes, sir.
I have to file only for processing.
No, requisites, you go and ask the office. They will tell you. Yes. Yes, sir.
Next week not possible. 7, 8, 9 we have already, now we have gone to 10 also.
Last week of July. What's this matter? In the last week of July 2025.
The students will fix date.
Yes, one date.
One date, you can fix some date. Na?
And the regional research files the additional affidavit that has not been taxed from the
court records to be updated. Okay. 29? 29.
At the last time.
Let us.
Today I received the counter file by the opposite party number 1. I press for 3 days time to find rejoinder or affidavit.
You want to find rejoinder? On 29th, we will give you 3 weeks.
Yes.
Any urgency? 3 weeks.
Interim order.
Call this matter on the same day. Interim order to continue till then.
I am appearing for number 2 and 3.
3. So it's
the counter may be certain.
Yes. I am for the petition.
In this case, a counter not filed.
Counter is not filed. You can take advantage of absence of counter also. How can we direct them to file? First week of August.
So actually at times when we are waiting, nothing is happening. The prudent method is to take fresh notice or notice afresh.
That's why.
Because waiting indefinitely for notice to be sufficient, so it becomes an endless process. So it's only a suggestion.
Parties are abroad. There is a separate provision in CPC for serving. You have to look into that one. No? There is some provision. Can anybody tell the court which is the separate provision in CPC which provides for serving of notice on the person on the foreign soil? There is such a provision on the amended CPC.
1 and 2, sir, registered was already received.
Service of notice, court notice by registered post. Acknowledgement due.
Yes.
Acknowledgement due.
18 not received, but the postal tracking report shows.
Although the acknowledgement card has not returned back to the sender. First up, in such an event, service is held sufficient.
1 and 2.
On respondents numbers, OP numbers 1 and 2. First up.
But Belgium is very good. But for the office to give great updated postal tracking for OP.
But in respect of foreigner, person duties on respondent number 3, who is said to be on the foreign soil. Okay.
So wait for some time. In the meanwhile, they will also obtain the updated postal tracking report of UP3. Maybe it will be served by the next date.
Post office service.
Order 5, Rule 25.
Order 5, Rule
25.
25. Just look into. I think it's amended in 2002. Just look it. Okay? So.
Number 39.
39.
On last occasion, your lordship have passed the order issuing notice to the opposite parties. Lord and Council, appearing for the opposite parties, has accepted the notice.
My Lord, we have received the affidavit from the NTA, National Testing Agency.
Yes.
But the hard copy we don't have, they didn't turn. So lordship may take it after 2-3 days or 5 days, it can be suffice our issue. But this preliminary submission of the NTA is there.
No, not preliminary. If you are ready, we will hear you.
We're
Not
ready.
on installment basis.
Then let's may keep it to
which date? You choose one date.
After 7 days.
Choose one date from the calendar.
My Lord, council process is already going to be.
When? That begins when? Counseling begins on which date?
2nd July, my Lord.
2nd July?
Yes.
Then lordship may alert for
tomorrow we'll have the.
Have you e-filed it or?
We have not able. Just to receive the mail, we just download it and come to the court.
Okay.
So lordship may give it.
Tomorrow we'll have this.
Yes.
Is it correct?
No. What the NTA says, what application they have filed to the court and annexing the document, answer paper, it is completely different from it is just somebody else. Yes. And it is given to us the which document possessed by his students and particular students. And even though he is belongs to Orissa, he is in Calcutta, he is definitely examination in Calcutta, they have not territorial education. But I am in the point that
he was residing, sir, at Calcutta. And
please don't debate.
I am not disputing anything. Only I am saying that whatever answer paper they have placed before my lord that I am eligible to get such and such marks.
They don't describe how they received, nor they disclose the email ID, nor any printout of the email.
Exactly.
That was the discussion.
Said other day. When
House have said that you have to disclose how you got that OMR sheet or affidavit. There is an order to that
But
effect.
my Lord, my humble submission before lordship, as the petitioner has not yet received the OMR sheet through email address registered at the time of registration of NEET examination, he has filed, he has forwarded an email message to the concerned authority to provide him the OMR answer sheet.
Anyway, we'll have this matter tomorrow.
Yes.
All right?
Yes.
All right. Call this matter tomorrow. Tomorrow, at the request of Learned Standing Council appearing for opposite party. Well, whatever you have, share that with your friend also.
Today I can give the documents, but it's a part document.
Whether counseling is from 2nd. Are you sure? Counseling is from 2nd. Who pays for the agency?
That date you should have ascertained. Because that day he was not sure. He said it will be
I need to be sure because all of a sudden
that instruction.
On what basis you say it is 2nd?
The petitioner has told me that the counseling process will be started. On
Any material.
Process may start, but it is continuous in long. Maybe if you start, even though accepting 22nd, it will continue a long process. It's not that overnight it will complete.
And according to you, what is the marks he has secured? Because he is projecting a difference of 180 marks.
99 is correct. 42 is wrong. Out of 180.
Anyway, then there is some wrong in that.
Yes.
Even on your part.
No, we have given we are maintaining transparency and giving all the documents to my. We are getting every documents. We'll fetch it over.
You gave him the your affidavit and everything together. It's right now.
Yes, sir. I am set up within half an hour. My SOT will do it within an hour.
Evening.
If lordship take it day after 2 weeks.
That's all. That's
Yes,
all. On Thursday we'll call this matter.
Yes.
Call this matter on Thursday, imminent.
Mobilizing.
At the request of the panel council. Yes. Imminent. Okay.
All the matter I am just passing on the sleeves, my lord.
Other matters are also there.
My last matter also I am not passing sleep. I just pass on the sleep.
Along with other connected matters.
Yes.
Okay.
This connected matter.
Anything about the mention the name of the concerned councils.
He is saying about the appearance.
Appearance of the council.
He will give you in a slip.
Yes. I will give
That way.
Wherever.
Okay. Then we'll call this matter on Thursday. Okay.
Passover? Please try.
Any pastor matters are there? Are over? So that. Discussion.